Thank you all for attending today, and we have one argument that's scheduled, one case I should say, that's scheduled on our docket for videotape anyway this morning, and that is State versus Williams. And each side will have 15 minutes to present their arguments. And if the appellant wants to reserve up to 5 minutes, you just let me know whenever we begin the argument if you don't care. I also want to alert you that we shouldn't be using any victims' names, and obviously children especially, but anybody's victims' names. We don't want to use those. Just refer to them as a victim or by initial or something, but no identifier, please. And as I said, we are being recorded and we're Facebook Live as well. So we have to keep our voices up. And also when you're not arguing, if you would mute yourself so that we would cut down on background noise, we'd appreciate it. Both attorneys are able to hear us fine?
Yes.
Okay. All right. Sounds good. All right. Attorney Manugo, if you want to begin, you can.
Thank you, Your Honors. May it please the court, Jessica Manungo on behalf of Jesse Williams II, and I'd like to reserve 2 minutes for rebuttal, please.
Thank you.
Mr. Williams faced a trial on 2 incidents that were completely unrelated. One involved someone he knew, and the other involved a stranger. And I will refer to them as complaining witnesses 1 and 2 as instructed. Mr. Williams' trial counsel rendered ineffective assistance when he failed to file a motion to suppress a tainted eyewitness identification, and when he failed to request for the jury to receive instructions about unreliable cross-racial identification. Counsel's ineffective assistance combined with the trial court's error in providing an emotional support dog that distracted the complaining witness in the rape case prejudiced Mr. Williams by painting him as a serial burglar who attacks vulnerable women. There is a reasonable probability that a motion to suppress would have been granted. This court in State v. Johnson found, based on the United States Supreme Court case Simmons versus United States, which we cite in our brief, found that convictions based on eyewitness identification at trial, following a pre-trial identification by photograph, will be set aside on that ground only if photographic identification procedure was so impermissibly suggestive as to give rise to a very substantial likelihood of irreparable misidentification. And that's what we have here. First, in this case, the photo array administered by the police was inherently suggestive. And even if it was inadvertent, the police arranged the array in a manner that made Mr. Williams stand out, in a way that said to the witness, "This is the guy." The array consisted of a total of 6 African-American men, including Mr. Williams. And not only was his skin tone darker than most of the men in the array, he was also wearing clothing that was completely different from all the other men in the array. And a similar issue of skin tone was before this court in Johnson. However, because the witness in Johnson had already provided a description of her attacker immediately after the incident, stated his distinguishing features, and her son had recognized the attacker after his mask fell off, this court did not reach the evaluation of skin tone. So unfortunately, there's no way of adequately assisting this court in evaluating skin tone differences, except by looking at the pictures in that exhibit. And I would note that although Mr. Williams and the complaining witness in the rape case knew each other, that witness did identify him in her photo array as the dark-skinned one. But even if the court decides, after looking at Exhibit 9, that there were no differences in skin tone, Mr. Williams was still the only one in regular clothing, and everyone else was in prison garb. In that picture, he was wearing a dark jacket, which is exactly what witness 2 had stated she remembered about her perpetrator. So again, even if this was unintentional, the state's failure to construct the array with attention to differences in skin tone among African Americans And just to elaborate, the lead detective who put together the array appeared to conflate skin tone and race when he said, well, maybe I factored in skin tone similarities, and so I would not add a white man to the array. But skin tone and race are two different things. So the failure to construct the array in a way that attended to skin tone differences and attention to similar attire, or rather attire that doesn't make someone conspicuous. That there, according to the Manson framework, that is state action or misconduct by the state that renders the array irreparably suggestive and unreliable. And Manson is very clear. Once an array or a pre-trial identification is inherently suggestive, that identification is not admissible. Second, the totality of the circumstances demonstrates that witness two's identification was significantly unreliable. She was in a dimly lit room. She became paralyzed with fear for about a minute before she pushed the guy out of the window. The opportunity she had to observe was limited in time. And in addition, social scientists have found that the likelihood of misidentification is higher when an identification is cross-racial, particularly when a Caucasian witness identifies an African-American suspect. On the night of—
Counsel, let me just interrupt you. Those are very, very thought-provoking arguments, makes a person think, but there was no expert testimony about any of this. There was nothing presented so that, that a jury or a judge or anybody could make that determination.
And this is where we're saying that counsel was ineffective. Because yes, there was no expert testimony, but because there was no expert testimony, if counsel had selected or chosen not to put up an expert witness, the least that counsel could have done was given the jury instructions.
But unfortunately, we have no record. We'd have to be hypothesizing or speculating as to what the testimony of an expert would be in this matter. Wouldn't we? Since there's—
That is correct, Your Honor. However, we do have a body of research that has developed since the 1980s, early 1980s, that does show that there is this own race bias or cross-racial bias.
Right, but all I'm saying is I'm trying to figure this out. It's not in front of us, though.
That is correct, Your Honor.
Okay, thank you.
But I just do want to stress that on the night of this incident, witness 2 provided a limited description of her perpetrator, limited simply to he was Black and he had a dark jacket. There was no mention of his eyes or of his facial features or any distinguishing features. However, a month later, after being exposed to the Fox News clip with Mr. Williams' picture and name as a person of interest in the rape and burglary case, and then further accessing an online article which had his picture, name, and again, describing him as a person of interest, there was a reasonable probability that witness 2 was primed by these exposures and the suggestive array, primed to believe again that this was the man who attempted to break into her house, again rendering the identification unreliable to the extent that the pretrial identification would have been suppressed. And yes, I did discuss it. This is closely tied to at least the other issue in the brief, which is the failure to request the jury instructions for cross-racial identification. And I understand the court's concern about this, but generally trial courts in Ohio are not required to give jury instructions on eyewitness identification when the issue of determining identity beyond a reasonable doubt is adequately covered by other instructions. But here the other jury instructions included credibility, essential elements of the charges, direct and circumstantial evidence. And these instructions did not address the issue of determining identity beyond a reasonable doubt. There were no discussions whatsoever about assisting the jury in eyewitness identification, let alone cross-racial ID. And so we are arguing that the confusion and the bias that resulted from witness number 2's testimony could not be resolved adequately by simply instructing the jury that it was the judge of credibility of witnesses. Because the landscape of cross-racial identification and because identification of Mr. Williams as the perpetrator was the central issue in witness number 2's case, it was necessary to specifically guide and direct the jury's attention to the very nature of, or the potential problems, at least, of reliability inherent in cross-racial identification, or eyewitness testimony in general, and just help them to navigate such a confounding topic. And yet, trial counsel, was duty-bound to just request a jury instruction. And finally, the trial court's provision of an emotional support dog to an independent adult, the record shows that this particular witness does not have a service dog in her home. But that provision resulted in the dog and its handler being a spectacle during the complaining witness's testimony. The witness was evidently—
Counsel?
Yes.
My understanding is that this particular victim who testified is developmentally disabled.
That is correct, Your Honor.
So wouldn't the case law be more appropriate to look at the case law regarding children than adults that are not developmentally disabled?
She is developmentally disabled, but this is not similar to her being a child. She cannot be considered a child because she is an adult and she does what adults do. She lives on her own. She works. She goes to the bar. She goes to places on her own. And so she was already presented as an independent adult who functions on her own. And the witness was evidently distracted. She occasionally spoke to the dog and to the handler and was non-responsive to questions that were being posed by the attorneys. And her testimony was inconsistent. He broke in. I let him in after he knocked, and all this led to her on the stand being more of a spectacle when she was providing her testimony. And in conclusion, because counsel failed to file a motion to suppress, failed to request for jury instructions that would cure the cross-race effect, and the trial court's sua sponte order for witness number 1 to use a companion dog, because of all this, Mr. Williams was prejudiced. We ask that this court vacate the conviction and remand for retrial. Thank you. Thank you.
Attorney Corrigan, you have 15 minutes.
Thank you, Your Honor. Good morning, and may it please the court. I am Jacqueline Corrigan on behalf of the state of Ohio, the appellee in this matter. And Your Honors, let's talk about what this case is actually about. This is actually an ineffective assistance of counsel claim. And that's the central issue here. But let's look at what Mr. Williams is asking this court to do in the context of an ineffective assistance of counsel claim. He's asking this court to declare as a matter of law that every time that there is a witness who has to identify a person of a different race, that there has to be a motion to suppress filed, there has to be expert witness testimony concerning cross-racial identification, and there has to be a request for a jury instruction concerning cross-racial identification. Those are unique rules of law that have not been given the blessing of the Ohio Supreme Court or this court or any other court in the state of Ohio.
Is she saying that, or is she saying when there's indicia of unreliability, in this case, the argument being that the photo used of Mr. Williams was suggesting that he was the perpetrator? Isn't she limiting it to situations where there are those indicia of unreliability, or that the statute, the factors in the statute weren't appropriately followed?
Well, that's not what I read from the brief. It seemed like the argument was that anytime that you have this kind of situation, that you have to raise these issues. And since the Ohio Supreme Court has not spoken to that, then essentially this court is being asked to make that kind of rule of law through the vehicle of an ineffective assistance of counsel claim. And that's improper, because no court can create a new rule or principle of law through this kind of vehicle. Because let's look at what ineffective assistance of counsel it consists of. It consists of objectively unreasonable failure by a counsel to meet their duties as an attorney. And through all of the state's brief, have cited case after case all the way up to the US Supreme Court that does not require an attorney to go with developing areas of law, to test out developing theories, to push the envelope of a state's law or a jurisdiction's law. We're not required to do that. We're required to be objectively competent. And by asking this court to, this is what's being asked, is you're being asked, Your Honors, to require counsel to push the envelope beyond which the Ohio Supreme Court has created a rule of law. That's not what's required to be competent counsel. And so this is
just quickly, if the photo array shows that Mr. Williams clearly stands out as different from the other individuals, is it ineffective for counsel not to file a motion to suppress if that's the case?
Of course, that's a case-by-case determination. Obviously, if it were really obvious that this person was being singled out in the array, then an argument could be made. However, as you're going to expect me to say now, is that's not what we have here. And if I were permitted to share my screen in this Zoom meeting, I have the photo lineup on my screen right now. I could display it for Your Honors. This is not a photo array where it's obvious that Mr. Williams is the person that the police want the witness to look at. It's his skin tone is shared by at least 3 other members, probably 5 other members of the people in the array. Yes, his clothing is slightly different. He's wearing a dark hoodie. It has white ties, okay, a white drawstring. Otherwise, there are other people in the frame who also are wearing dark colored shirts over a white undershirt. So there's really no significant difference in any of these photos that would say, look, this is the one, okay? And that's that kind of thing where there's an obvious difference that invites the person to look at that individual and say, that's the person the police want me to identify. That's the kind of thing where that would be an impermissibly suggestive array, and that we would expect somebody to file a motion to suppress on. But that's not the case here. So we don't have that impermissibly suggestive procedure happening. And then it's only if you have that you then move on to the reliability of the identification. And in this case, since we're only talking really about the second victim of the attempted burglary, I would remind the court about what the testimony actually is. Yes, it was in the middle of the night, but her room was lit by her television and a lamp. She spent anywhere from 30 seconds to 60 seconds face to face with him at arm's length, trying to shove him out of her window. Okay, she was very close. And the thing that she testified that struck her about this person whose whole torso was inside her house was that She noticed his tired eyes. That was the thing that stood out to her. So she did look at his individual features of his tired eyes. And so this isn't a case where you have a fleeting glance at somebody where you don't really have a good idea of their features. This person did. In fact, she had face-to-face, close distance contact with this person and a good opportunity to view him over a time frame that, at 30 seconds, that's about a 30th of the amount of time that I have to talk to your honors. And if it's a
Was her initial description limited to black male, dark jacket? Or did she get into the details of the eyes and the face?
I don't recall that she got into the details, but once she saw the Fox News story on TV, she recognized from the eyes that was the individual who had broken into her apartment. And I would remind the court that just because there's a news account that displays somebody as being a defendant or a suspect in another case, this court's already faced this situation in a case that we cited in our brief, that that doesn't necessarily become an impermissible procedure or a suggestive procedure because it's not state action. So, just viewing news coverage does not render a photo lineup impermissible. And let's also talk about, I want to briefly touch on the second victim, the victim of the rape. This was not a spectacle with Avery, the facility dog. Yes, this victim she's a high functioning MRDD client, but she is significantly managed. She lives alone, she lives independently, but she's significantly managed. She doesn't pay her own bills. She has a payee who takes in her supplemental Social Security. She has healthcare workers that come to her residence twice a day to make sure she gets her medications. So she's not managing her medications on her own. She's not managing her bills on her own. She doesn't pay her rent on her own. She has a job, but it's at a sheltered workshop. Okay. And so this is someone who is not at the level that we would expect of a non-MRDD client adult. Okay, this is someone who is functioning more at the level of a minor. And also, Your Honors, this court has never imposed a cap on the age for which someone can have Avery in the courtroom with them. In fact, this court actually commented that there does not seem to be, or there does not seem to be any reason why there should be an age limit, such as to limit Avery's participation to only children witnesses. So, and because of the unique characteristics of this particular victim, she is more like a minor than she is an adult in many respects. So that's all I want to say about Avery at this point.
Quickly, was the dog visible to the jury where it was situated?
According to what limited information we have in the record, it seems like Avery was under the witness stand because there is a reference to him being on the witness's feet. So,
but he was led into the courtroom as opposed to having been placed there prior to the witness taking the witness stand. In other words, I suppose you could do that where you place him in an area where he's not visible to the jury, then bring the jury in. That was not the case here.
There's no indication in the record really on how Avery was introduced to the courtroom. But the court did tell the jurors, look, we have a facility dog in the courtroom with the witness. You're to ignore him. Don't try to look for him. Ignore the fact that he's here. Do not make any assumptions or any presumptions about the merits of the case based on the fact that there's a golden retriever Labrador in the room. So, the court was very specific and lengthy in its cautionary instructions when this witness was about to testify. And then also in the final jury instructions themselves, the court reiterated, don't, to the jury, do not make any conclusions based on the fact that a dog was here. So that, we presume.
And then one last question, was there any proffer as to any reactions by the jurors, et cetera, to the dog?
No, nothing in the record at all. Not even proffered. And this court in the past has held on a couple of occasions, and it's been adopted by other districts, that having a facility dog in the courtroom is part of the trial court's inherent right and power to control the proceedings before it, and does not necessarily constitute a deprivation of fair trial for a defendant. So, and there really is no evidence in the record that Avery was a distraction or a disruption. There were only 3 references to him that the witness made. One was that he was sitting on her feet, she couldn't move them. Another one was she told him to sit. There's no indication that he was visible, shifting positions under the witness box. And the other thing was that where she was describing what her job is, which is assembling dog toys, that she apparently looked over to the dog's handler and suggested that the handler get him one of the toys. That was it. So he really wasn't a spectacle. And given the court's instructions, we do presume that a jury is going to obey the instructions that the trial court gives them. So that's my conclusion about Avery. But otherwise, the state's position is that there wasn't anything that was inherently impermissibly suggestive about the photo array that was used with witness number 2, or the attempted burglary victim, and that the procedure that was used did not result in a very substantial likelihood, of irreparable misidentification of Mr. Williams. And really, with the reliability factors, the court needs to review those, and that's the witness's opportunity to view the offender during the crime. Again, she had at least 30 to 60 seconds face to face with him. There's the witness's degree of attention. She was paying attention to him. He was right in front of her for that period of time. The level of the witness's certainty, and she was not perfectly certain, but highly certain of her identification of him, and the length of time between the crime and the identification. I mean, she did call the police right away. And yes, it was after Fox News put Mr. Williams' photo on the news that she realized that was indeed who broke into her apartment. But as soon as she saw that, she also notified police.
Was there a motion to use the dog in the case, or anything in the record that would indicate why the dog was necessary in this case?
I don't recall that the state filed any motion. So
is it necessary for the court to make that inquiry before allowing a dog in the courtroom?
I don't think that issue has been litigated, and if it hasn't, maybe not to my knowledge, but I know that in some cases the state has made a motion, but generally those motions were filed early on in this office's use of the facility dog. And I'm not certain whether motions have been filed in every case since this court has actually reviewed the merits of having a facility dog in the courtroom.
Okay, thank you.
And I'm not sure what my time is.
I was just going to say, and with that last question, you're out of time now.
Thank you very much. The state urges you to affirm.
Thank you. And you have 2.5 minutes left for rebuttal.
Thank you, Your Honors. We're not asking this court to create a new rule. It is when the indicia, as Your Honor did specify, it's when the indicia of unreliability and suggestiveness are combined, that is when you have a case of unreliability that goes to the threshold where the evidence is not admissible. And where you have something like one of these things is not like the other, that is inherently suggestive. And so you have Mr. Williams, who had a different skin tone, but more than that, he was dressed differently from everyone else. Yes, witness 2 remembered the eyes, but she didn't describe the eyes immediately after or any other distinguishing features after the perpetrator who came into her house or after that incident. There was no description. Her description was limited to he's Black and he wore a dark jacket. And so if an array is arranged in such a way that someone stands out and the array is controlled by the state, by the police, that is state action. And Manson is very clear. If the police have a hand in it, it is state action. And we're not saying that the police had anything to do with the media exposure. No. What we're saying is their arrangement of the array, plus the unreliability or the totality of the circumstances, make this particular evidence, it would have been, or there is a reasonable probability that it would have been suppressed. So whether we use the Manson test or the rules of evidence, which is the alternative argument we had in our briefs, Mr. Williams would succeed under either. Yes, some of the cases that were cited were out of state high courts, and the state did refer to them as untested and unapproved legal theories. But the rules of evidence have been in existence as legal theories in Ohio for decades. So because the court may exclude relevant evidence if its probative value is substantially outweighed by the danger of unfair prejudice, because of all this, Mr. Williams would have succeeded under the rules of evidence.
Thank you, counsel.
Thank you.
I'm sorry, you're out of time. Thank you both for your excellent presentations here this morning. I really appreciate it. And we will take the matter under advisement and we'll issue a written opinion that will be sent to both sides. And obviously, you know that you can also look on the website. And then our next video oral argument is scheduled for Thursday, June 3rd. So thank you very much. And I hope you enjoy the rest of your day. Thanks.